most police officers are out there doing a great job, doing their best. And the public has the right to know that, just as the public has the right to know when officers are engaging in inappropriate misconduct.
I'm Justin Silverman of the New England First Amendment Coalition. NEFAC, along with the Society of Professional Journalists New England chapter, recently presented lessons on the Federal Freedom of Information Act and state public record laws. These classes are taught by leading open government experts and attorneys, and they're all now available to view. So please check them out, along with the many other helpful classes and tutorials we offer. They're all at nefac.org or right here on this YouTube channel. I'm here today with Gregory V. Sullivan, a longtime NEFAC board member who serves as general counsel for the union leader in New Hampshire. Greg, thanks for joining us.
My pleasure, Justin.
Greg, you recently filed an amicus brief on behalf of NEFAC and the union leader in a New Hampshire case involving public records and alleged police misconduct. Before I have you explain the arguments that we made in that brief, can you first give us the facts of the case and tell us how it came before the state Supreme Court?
Yeah, as I understand the facts, a woman in Canaan, New Hampshire, had heard that her child's bus driver had a lead foot. So she decided to investigate for herself and was following the bus on its route. Someone apparently thought that was mysterious and alerted the police, and a police officer, Samuel Provenza by name, pulled over, turned on the lights and pulled over Ms. Eastman. She believed that he knew who she was, but in any event, he requested her license and registration. There's a dispute between Ms. Eastman and then Officer Provenza about what transpired, but Officer Provenza alleged that she refused to produce her identification. He therefore ordered her to get out of the car. She refused to get out of the car, and she admits that because she says she was afraid of his behavior. He had previously placed his head inside the driver's window after she had lowered it, and she testified that his lips were close enough to hers that he could have kissed her. But in any event, the officer then opened the door, and Ms. Eastman alleged that she was pulled by her ponytail out of the car, and as she was exiting the car, she was kneed by the officer in her leg. Fast forwarding, she needed surgery on that leg. It was a serious injury. She was arrested and charged with disobeying a police officer and resisting arrest was the second charge. Disobeying a police officer and resisting arrest. That case went to trial. She was found guilty of disobeying a police officer and not guilty of resisting arrest at the trial court. And the state appealed that to the Supreme Court, and the Supreme Court affirmed both the guilty and the not guilty findings. Thereafter, Ms. Eastman filed a complaint with the town of Canaan alleging that the officer had used unnecessary excessive force. The town hired a company called MRI Inc. to investigate an independent investigation as to what happened. Subsequent to receiving the report, the police chief issued a statement saying that the report found that the allegations of excessive force were without merit. Now, the Valley News, the local newspaper, had been following the story, writing about the story, and requested a copy of the MRI report. So to make a long story short, the town refused to hand over the report. Valley News sued in the Superior Court, represented by two terrific First Amendment attorneys, Yale Bissonette and Henry Clementowitz, both with the ACLU of New Hampshire. They, representing the Valley News, successfully got the court to order the MRI report to be furnished to Valley News and to the public. Officer Provenza, he was a Canaan police officer at the time of the incident in 2017, and he's now employed as a state trooper in New Hampshire. So the argument of Valley News all along has been, this is a matter of public interest. And in New Hampshire, we have a statute, Chapter 91A, which guarantees the public's access to all proceedings and records of governmental actors and agencies. We also have a constitutional provision in New Hampshire requiring openness and transparency in government, it being essential to a democracy. So the case is now before the New Hampshire Supreme Court, and Justin and you, other members of the Board of Directors and Executive Committee of New England First Amendment Coalition, determined that we should file an amicus brief in support of the Valley News position. So I was happy to do that, and my longtime client, Union Leader Corporation of Manchester, had also requested that I file a brief. So I filed a brief on behalf of both organizations supporting the Valley News position that the law requires that this report be issued to the public. Now, we're able to say that in 2021 because of 3 cases that the Supreme Court of New Hampshire decided in May of 2020. That was Union Leader versus Town of Salem, Seacoast Newspapers versus the City of Portsmouth, and Mary Ann Salcetti versus the City of Keene. And in all 3 of those cases, the Supreme Court ruled that when determining whether or not law enforcement records in those cases should be disclosed, it requires a balancing test between the government's interest in not disclosing, any individual's privacy interest in not disclosing, to be weighed against the public's interest in disclosure. And we say that the legislature has determined which side of the scale in those cases, if all things are even, the scales tip in favor of disclosure, and that's the purpose of the right to know law in New Hampshire. So the Valley News, Trooper Provenza, Union Leader, and New England First Amendment Coalition all now have briefs pending before the Supreme Court.
So explain to us, Greg, why that is. If the law is clear and this balancing test needs to be used, why are we in this public records dispute? What were the arguments made against the disclosure of this report?
It's an interesting issue, and I think it's going to be a case of first impression in New Hampshire, because in all the other cases, when we're looking at police misconduct, it seemed quite apparent that indeed there was misconduct. In this case, the MRI report says that the citizens' allegations were without merit. We're arguing that we're not only trying to look at the actions of then Officer Provenza in this case, but we need to look at the job that MRI did, whether or not this town did the right thing after receiving that report. And Officer Provenza, on the other hand, is arguing that because these charges were unsustained or without merit, it would be an invasion of his privacy for this report to be disclosed to the public, which to me is a little bit ironic, because if the report shows that he did not engage in any inappropriate behavior, why would he not want that fact? I've often said that the right to know, the sunshine of public scrutiny, sheds light not only on bad conduct, but on good conduct. And we've seen that many times. And we all know that majority is not a big enough word, that most police officers are out there doing a great job, doing their best. And the public has the right to know that, just as the public has the right to know when officers are engaging in inappropriate misconduct.
So you mentioned that this is a case of first impression. For those that aren't journalists, for those that don't have a legal background or who may have never interacted with a police officer, can you explain to them why this case is important? What's at stake here?
Well, again, what's really at stake is whether or not a finding of unsustained, as it's often called, or without merit in this case, whether the documents supporting that finding are going to be disclosed to the public. And again, we allege they need to be, not only because so that we can have a better understanding of what happened in a particular instance or a series of instances, but how the supervisory personnel, whether it's the chief of police or in New Hampshire, we have the New Hampshire Police Standards and Training Council, and we've got another case pending on behalf of Union Leader against the New Hampshire Police Standards and Training Council, where they're saying we're not going to give over any records where the allegations were unsustained. And that really deprives the public of analyzing not only the conduct of the involved officer, as I've said, but also of those charged with the responsibility of supervising those officers. So it's kind of a two-tier level of inquiry that we believe the citizens have the right to make.
So we have these briefs filed. What now? When is the court expected to hear this case, and what's the best possible outcome?
Well, with respect to the first question, pre-pandemic, I probably would have an educated guess, but nowadays, as I'm sure you and the public are aware, we've got a huge backlog of cases at every level of courts, not only in New Hampshire, but nationwide. So I don't know the answer in terms of a scheduling. Well, the best case outcome, of course, is the Supreme Court affirming the Superior Court saying, yes, of course, the public has a right to know about the report and about how the town responded to that report, whether or not the town, in releasing a statement saying that the allegations were without merit, is that exactly what the report told the chief and the town? We need to know that. And we need to know what were the facts that were presented to enable this report to come to its conclusion. And I should, as a footnote, note that Ms. Eastman currently has a lawsuit pending in the federal court, the United States District Court for the District of New Hampshire, against Trooper Provenza, again, making the same allegations that she was seriously injured by the use of excessive force. Another interesting footnote to me in reading all the facts of the case was that New Hampshire cruisers are now, and officers are fitted with body cameras that will, and I think they're great. There's no more he said, she said, if it's all recorded. And for some reason, which the town hasn't explained, in this case, they released a statement. The town administrator said, we have video cameras in the cruises, but on occasion they don't work. It's not an intentional thing. So somewhat unfortunate that in a case where we have an encounter between an officer and a citizen, and the citizen is alleging, in this case, excessive force, it's too bad there isn't a video. If I can take another minute, an interesting point to me, when the legislature passed Chapter 91A, the Right to Know law, they listed exemptions, things that the public don't have the right to, information about juries or students in school, per se exempt categories. But they did not include anywhere in the statute law enforcement records. So the Supreme Court of New Hampshire in 1979 said we're going to follow federal law in that regard. And federal law 5 U.S.C. 552 specifically lays out areas where the public does not automatically have a right to records. And they're very specific. One is if it would interfere with an ongoing investigation, would it disclose the identity of a confidential informant? Would it constitute a wrongful invasion of privacy? And that's where the rubber meets the road. That's where most of these cases are litigated. And now in 2020, at least the Supreme Court of New Hampshire is saying, let's apply the balancing test. Whereas from 1993 to 2020, these records were ruled to be exempt per se. So those three cases I mentioned from 2020 are absolutely monumental in terms of the public's right to know what the government is up to in New Hampshire.
Greg, thank you so much for walking us through all of the arguments in the brief and all your help drafting that brief and filing it on behalf of NEFAC.
Well, I hope it's been helpful. It's an interesting and complicated area of the law.